Shavi is agreeing to pay Makand if she marries Itesh. Unfortunately, Makand died. So now the contract is void. When contracts become void, which are contingent on happening of specified event within fixed time. On the other hand, it is possible that when the promisor attempts to perform his promise, the promisee refuses to accept it. In such cases, it is called attempted performance. Warm welcome to 4th BCom student. The subject we're discussing business regulatory framework. I'm Professor Rajesh LR from Department of Commerce and Management, Vidhyaashram first grade college Temple of Excellence. In our previous session, we discussed about appropriation of payments as per the debtor and creditor concepts, quasi-contract and types of quasi-contracts. In today's session, we are going to discuss contingent contract, the event which may take place or may not take place at that time. What is the concepts we have here? And even we're going to discuss rules regarding contingent contract, discharge of a contract, modes of discharge of contract. There's a concept what we're going to learn in the present session. As per the examination point of view, discharge of contract, modes of discharge are compulsory for the section B 10 marks question weightage. They may ask you people, just go through this session. Contingent contract. So we have a contract may be absolute or contingent. See, absolute means when offerer and offeree has made an agreement where offerer has performed all the duties of the agreement and even offeree has performed his duties of the contract. So then it is called the contract is discharged. Means without any conditions, both the people act according to the agreement, whatever they made or the contract, what was there. In the contingent contract, it is a type of contract where the performance is dependent on some conditions which may happen or may not happen. Like for example, when we make an insurance like general insurance, that is, let us take example of fire insurance. When we make a fire insurance on our residential property and the property is now, the risk is covered on the property like for the purpose of fire accident only, not for other things. The insurance policy has taken here, the risk has been covered only for the fire and not for the other concept. Now, if the property is been lost for the effect of fire or the cause of the event which has damaged the property should be the fire only within the 12 months of the period what we have taken the insurance for the property here. That is, when I take a policy here on 1st May, from 1st May 2023 to 30th April 2024. In this 12 months, if anything happens to the property, then the insurance company is going to make the payment for the loss or the damages for the property. Now, if nothing has happened here, the insurance company is not going to pay anything. This is a concept what we're going to call contingent. See, the example what already I've said that Vasuli buy contracts to pay Bapi by 5 lakh rupees. If Bapi Bai's house is burnt, this is a contingent contract. Contract of insurance, indemnity and guarantee are also example of contingent. If anything happens to the property, then I'm going to pay you 5 lakhs. That is only when your property is lost due to fire. It is burned totally. So then I'm going to pay you 5 lakhs. If that incident has not happened, I'm not going to pay you anything. This is a concept of contingent. What are the essentials are they? There must be a contract to do or not to do something. They're saying that one, the act may or may not happen. Like for example, I may give the example like we are going to have a contract between us. I'll say that one, as in the present scenario, the IPL matches are going on. So based on that example, I'll say that one, today, Rohit Sharma is going to cross his runs, like above 50 runs is going to score within 15 balls. I said that one, Rohit Sharma is going to score 50 runs within 15 balls. if that event take place, I'm going to pay you certain amount. If it doesn't happen, the contract is cancelled. It is a void contract because it is not possible, or sometimes it may be impossible based on these situations. This is the concept what we have. The event must be uncertain, not fixed. The event what we are going to have here, it should be uncertain, not fixed here. That's the concept what we have. The event must be collateral or incidental to the contract. It should be incidental part, not on the fixed part here. Section 32, 33, 34, 35, 36 of ICA 1872. What it says for us. Enforcement of contingent contract on an event happening. Say, for the event which may take place in the future, on that concept, we are going to have a contract. Like, for example, Alex promises to pay Peter 5,000 rupees if the ship reaches the port. They're saying that Alex has agreed that one with the Phillips, stating that one, or Peter stating that one, I'm going to pay you 5,000 if this ship reaches the port. If the ship doesn't reach the port, the contract is void. The contract is totally void. That's the concept what we have here. The next one, enforcement of contract. Alex agrees to pay Peter a sum of rupees 10 lakhs. If a certain ship does not return and the ship is sunk, the contract can be enforced after the ship sinks. On the other hand, if the ship would have returned, the contract would have become void. They're saying that now let us have a contract between us where I'm making contract with you. The ship which has gone on 15th April 2024, if that ship sinks in the water, I'm going to pay you 10 lakhs. If the ship returns back safely, then I'm not going to pay anything. That is nothing but the contract is void. This is the concept what we have. Contingent contract dependent on future conduct of a living person. Now, here we are going to have a contract here. Shervi is agreeing to pay Makand if she marries Hitesh. Unfortunately, Makand died. So now the contract is void because it couldn't perform. The contract could be performed here. Next, when contracts become void, which are contingent on happening of specified event within fixed time. Alex promises to pay Peter 5,000 rupees if the ship does not reach a port within 1 year. So here, the time is fixed here. He says that when the ship has left on 10th April 2024, it has to reach before 9th April 2025. If it reaches that one, then I'm going to pay you 5,000. If it doesn't reach before 9th and if it reaches on 10th April 2025, the contract is void. So this is the thing what we have here. Rules regarding contingent contract. Alex promises to pay Peter 5,000 if the ship reaches 1 year. Now contract will be enforceable valid if ship reaches the port within 1 year. On the other hand, if the ship does not reach within 1 year, then the contract is void. This is a concept what we have here. Agreements contingent on impossible events void. Like Anuradha promised Shyam to pay 1 crore rupees if he brings Taj Mahal from Delhi to Mumbai. Anuradha is making a contract between Shyam, saying that the Taj Mahal what we have in Agra, you just bring that into Mumbai, I'll pay you 10 crores to you immediately. It is not possible. It is an impossible event. Next one, discharge of contract. Modes of discharge of contract, it may be performance, agreement, operation of law, impossibility, lapse of time, breach of contract. Breach means cancellation due to certain reasons what we're going to discuss. Discharge by performance. Peter agrees to sell his cycle to John. Peter is agreeing to sell his cycle to John, and where John has to make the payment of rupees 10,000. Peter has handed over the cycle to Mr. John. John has paid the 10,000 to Peter. The agreement is valid. The contract is valid. That's it. This is called discharge by performance. Here, actual performance, attempted performance. Actual means when both the parties fulfill the terms of the agreement. On the other hand, it is possible that when the promisor attempts to perform his promise, the promisee refuses to accept it. In such cases, it is called attempted performance. Like John agreed to sell his bicycle to Peter. John has made attempt of selling his bicycle to Mr. Peter, but Peter has refused due to certain reasons. This is called attempted performance. Discharge by agreement, where the agreement between A and B has been made here. Due to certain reasons, they want to modify the agreement. Modification of agreement in ICA 1872, we say that one novation, which means modification of agreement between the parties due to certain uncircumstances, concepts, the agreement has been modified. Alteration. Alteration means change in one or more of the terms of the contract. When more than one point or one terms and conditions has been modified, we are going to call it as alteration of the agreement. Rescission, it means cancellation of the contract. Remission, it means acceptance of lesser fulfillment of the terms of the promise. Then saying that one, out of 10 points, 8 points has been agreed. That is called remission. Waiver. Waiver means giving up or foregoing certain rights. Okay, you have accepted to buy a product. Okay, no problem. Out of 10 conditions, you are accepting 8. Chalo, the contract will be continued here. So I'm going to leave 2 points as per the request what you made. That is called waiver. Discharge of a contract by lapse of time. They say that Peter takes a loan from John. Peter is taking a loan from John and agrees to pay installment every month for the next 5 years. However, he does not pay even a single installment. John calls him a few times, but then gets busy and takes no action. 3 years later, he approaches the court to help him recover his money. However, the court rejects his suit since he has crossed the time limit of 3 years to recover his debts. That's saying that one. When a debt has been given to a party, within 3 years, if the debt is not cleared, then the person who has given a debt, he can approach the court. If it crosses above 3 years, then they don't have any rights to claim that one, or he cannot approach the court. The settlement has to be made outside. Discharge by operation of law. If certain contracts are stopped due to death of anyone, either it may be an offerer or offeree, at that time the court approaches and completes the or performs the contract as per the agreement. Insolvency, the insolvency of promissory discharge, and they're saying that one, when there is insolvency, a person is not able to make the payment at that time, the court involves and says that one, before the insolvency date has been announced, the contract was made between the parties. Now, whatever the property are there available in the name of the insolvent, that has to be discharged for the damages. And if nothing is there, that wait for the next concepts. Unauthorized material alteration, it says that when the other party has made the changes in the contract without informing the other person. So that is called unauthorized alteration. Merger. When inferior rights of a person under a contract merge with the superior rights under any new contract, the contract with inferior rights will come to an end, where a part-time lecturer is made full-time lecturer. Merger discharge the contract of part-time lecturership. Saying that when I was working as a part-time faculty, there was a benefit for me. Whenever the classes are there, at that time I was coming, and after the classes I was leaving. When I became a full-time lecturer, it is my duty to be there from morning to evening in the institution. The previous relationship what we had in the part-time, that will be merged with the new rules and regulations of full-time employability, whatever it is. Modes of discharge. Last, discharge by breach of contract. Breach means failure of a party to perform. If any one person fails to perform his duties, then the contract is called breach of contract and it is called void. Discharge by impossibility of performance. A and B wanted to marry each other before time fixed for marriage. A goes mad, the contract becomes void. See, A and B agreed to get married within 12 months, but unfortunately, A has become mad due to pressurized work and the working environment conditions or any other reasons. Based on that, he became a mad. Now, the agreement between A and B is void because it is an impossible event. In the upcoming session, we are going to discuss about breach of contract and remedies for breach of contract. Namaste to all 4th Sem BCom students. Go through this session clearly. It supports for you people for the examination. Thank you to all.